copyright to that work, okay? And it went into effect the minute you wrote it down. No formalities are required. You don't have to publish the work in order to get the copyright. You don't have to register the work to get the copyright. However, registering your work, which involves recording your copyright with the U.S. Copyright Office, is a good idea. We'll talk about that in a minute. So who owns the copyright? Well, it's the author, okay? Initially, anyway. I'll talk about a way that somebody else might own the copyright in a minute. But who's the author? That's the real question. A photographer is the author if the photographer is self-employed, or if you're on the job and, or if you're employed rather, and you're not on the job when the photo is taken, or you're not acting in the scope of your employment, is a phrase that you might hear. So a good example of this is, I'm an attorney. If I'm walking to the courthouse and I see a flower on the side of the road and I take a picture of it, I own the copyright to that. My firm's not going to claim that I took that picture in the scope of my employment. Another example, my husband, pictured here, is a staff photographer for a newspaper. But every day he comes home from work and he takes a picture in our house, and he calls it the last picture of my day. Great blog if you want to go visit it. But those pictures are his personal pictures. They're not taken in the scope of his employment. They're not part of his job. So, so the newspaper, although they own the copyright to the work that he creates during the day and while he's on assignment, they don't own the copyright to pictures he takes while he's on vacation. So a company might be the author of a work if you're an employee, as I discussed a minute ago, as opposed to a freelancer, or if the photographer's job involves taking, if you're an employee and the photographer's job involves taking pictures. In that case, you know, it has to be, like I said, when the photos were taken in the course of employment. So you're not at home, you're not on vacation. Or if you're not an employee, if you signed a work for hire agreement. So work for hire is one way that a company can own the copyright, as I said. Now there's two ways a corporation might achieve a work for hire. The first is that employee scenario that I talked about. You're taking pictures in the scope of your employment and you're an employee. The second scenario is a work for hire agreement. So this is a contract, but in order for a work for hire agreement to be effective, it has to be in writing and it has to be signed, okay? So you're not accidentally in a work for hire situation. You don't impliedly end up in a work for hire situation. You have consciously gotten there. A corporation might also end up owning the copyright to pictures or works that you create if you transfer it to them. Again, a copyright transfer has to be in writing and signed, okay? So this is this way because you don't want to give up your valuable rights, and when they created copyright law, they did so in a way that would prevent you from transferring your valuable copyrights in, you know, accidentally. It has to be a very conscious decision. So think about it. If you're not an employee, if you're not getting a salary, or you know, maybe you're getting benefits, maybe you're not, but you're getting a salary if you're an employee. If you're not getting a salary and you didn't sign something, then you're probably the owner of the copyright. That's essentially the default. So without owning the copyright, how can a publisher use a work? Well, they can use it with permission, typically something called a license, right? They license the image from someone who has the rights. That may be from the person themselves or from the agency. But remember that license to use a photograph for one purpose is not permission to use it for all purposes. So when you license your work for somebody, to somebody, you license it for a specific use. Now, we talked a lot about what's needed for a company to end up owning the copyright or transferring the copyright. It has to be something in writing and it has to be signed. But a license, which we just brought up, is much more informal, right? All that's needed for a license is an agreement or permission. And something you should know, so yes, of course, your license to a company to use your work can be in writing, but it can also be oral, and it can also be implied. So I'll give you an example of an implied license. I got married, was it 17 years ago? Back in the day when people still used film. So the guy that took pictures at our wedding, a friend of a friend, nice guy, wonderful pictures. But what he did was he took the pictures and he gave us the film, which we then developed, and now we have the negatives. So do we own the copyright? No, we don't own the copyright because we didn't sign something over, or he didn't sign something that says, I transfer the copyright. But might we have an implied license to use those pictures to go make prints, to hang on our wall, to put in a photo album, that kind of thing? Yeah, I think that there's a good argument that we have an implied license from him to make prints from those pictures. So let's fast forward to 2017. How might you end up impliedly giving someone a license? Well, let's say you email someone your work. If you don't put any restrictions in that email on what they can do with the work, they might come back at you with an argument that you've impliedly licensed them to use the work. So the best course of action, anytime you provide somebody with your work, maybe they want to look at it to see if they really want to license it, make sure that you put terms in there saying, you know, here it is, you can't use it until we've come to an agreement, or if you want to go ahead and use it, you know, let me know and I'll send you an invoice for whatever. So just be very careful that you don't end up giving someone an implied license when you don't intend to. Okay, so now we figured out when you made your copyright. We figured out who owns the copyright. Now let's talk about protecting your copyright. The best way to protect your copyright is to register it with the U.S. Copyright Office. Now, why would you want to register it? The main reason is that if your work is infringed and you've registered it before the infringement, you can get statutory damages and attorney's fees. This is useful because it's often very hard to prove what your damages are when someone's used your work without permission. So statutory damages provides a range, and a court can award something within that range. But the real benefit too is attorney's fees, because if you have to hire somebody to take your case to federal court, it's very expensive. There are attorneys that do copyright law that work on contingency. They're much more likely to take your case if they know they have a chance of getting attorney's fees at the end of the day. There is a 3-month grace period. So if you register your work within 3 months of first publication, then it falls under that statutory damages and attorney's fees benefit. So don't feel like you have to register it before you publish it in order to get this benefit. For photographers, there's something very useful called group registration. You can register a group of photographs. You can register them as published, or you can register them as unpublished. You cannot mix and match your published and unpublished in a group registration. There's a tutorial on ASMP's website. I'm going to just plug them here, and it walks you through the registration process. I'm going to click real quick on this just to show you. I'm not going to run the podcast for you, but I just want to let you see kind of what it does here. So you'll see, she just walks you through the process, the charts, all that stuff. It's a really, really useful webinar. You'll notice that the Copyright Office website looks like it was designed in some time ago, and you know, it probably was. So anyway, I encourage you to go there, learn more about registering, read about it. But let's talk now. You've created your work. You own the copyright. You know when you got the copyright. Now you've registered it to protect it. Now you want to license it. So now you need to create a contract. Okay. A contract is basically an exchange of promises. Okay. You would say, I promise to take pictures, and you promise to pay me. That's an exchange of promises. You notice that on both ends of those promises, there's something of value, the use of the pictures and the money. would be the exchange, okay? Now, the important thing to remember is that a contract can be made in many ways. You could do it over the phone. Let's say you call somebody, and you make contracts probably all day long, okay? But let's say you do it over the phone. You call somebody and say, hey, can you babysit my kids? I'll give you 20 bucks. You made a contract, believe it or not. Email, you know, you might have an email exchange with somebody. Can you write the story for us? Yes, I can. Here's what I charge, or here's what we pay, you know, back and forth. You could happen in person. Somebody runs up to you, you know, they want to sell you something. You negotiate, you know, oh, it's $5. $5, that's too much. I'll give you 2. Okay, sold. That's a contract. It's a very simple, basic one. You can see on the right, I've created a contract with a text message. And you can also, of course, create a contract through something like, you know, a 40-page closing document that you would sign when you buy a house. But I want you to remember here that you don't have, it doesn't have to be, you know, an inch-thick document for it to be a valid contract, okay? The basics of a contract are an offer and acceptance, and there's also something called consideration. So, like I said, you could have an oral photo agreement, an oral agreement to create photo services or license someone a photo. Can you shoot this? Yes, I'll shoot it for $1,000. Okay, it's a deal. Once that is accepted, you have a deal, okay? A more likely scenario is they'll offer you something, maybe you'll come back, reject that offer, or counteroffer. Once you get to the point where both sides are in agreement, that's when you have the contract, okay? So the contract does not come into play here, okay? Contract's not created here or here. This is not enforceable, but it is enforceable once both sides say, okay. Now, why use a formal written contract, right? You've already heard me talk about how you can create a contract just through very simple methods, okay? But the reason to use a formal written contract, in my opinion, not just to protect yourself, but it keeps everyone on the same page. It's part of the professional communication that you're engaged in with your client. You want to make sure that if the client is expecting broad usage rights to your work, that you're providing it for them, and of course that you're pricing it accordingly. But if you don't have all that down in writing, then those issues are not spelled out ahead of time, and there can be confusion and hurt feelings in the end. Down the line, you want to remember what rights you gave your client. If you just had a phone conversation and then 10 years from now they call you and they say, remember that work you did for us? We want to reuse it. Well, you want to be able to go into your file and pull out that agreement and say, oh, sure, well, here was our agreement, and here are the terms related to using it again, and this is what we've agreed to, so here's where we go next, okay? So that's very useful, and every now and then somebody will contact you and say, hey, I want to reuse your work for this or that or the other thing, and you know, you still have bills to pay, so it never hurts to have an opportunity to earn a little extra. Another important thing about a contract is it tells you what happens when something goes wrong. Most of the time, nothing will go wrong, but every now and then you'll show up at the assignment, or you know, something will happen, or you'll get a call right before you're about to leave, and something has happened where the client cancels out on you, or the client's employee cancels out on you. So you want it to be clear. Okay, well, this happened. Well, here it is. Now we know what to do next. You know, I've had this happen to me where I showed up and an employee like left, even though he knew that we were supposed to take a picture. Well, that wasn't on me, and I certainly had turned down other work and taken my time to travel an hour to this assignment. So all I did was, you know, call the client and say, hey, you know, so-and-so was a no-show. Not only did they leave, they weren't willing to come back, even though I was willing to wait. So, you know, here it is in our contract. This is where we go next. So they did. You know, they met their obligation, and they continued to call me. You know, so this a scenario that goes a little bit awry can go very awry if you haven't determined ahead of time what's going to happen if something goes wrong. But by determining ahead of time what happens if something goes wrong, then when something goes wrong, everyone can just live up to their responsibilities according to the contract and move on. So your goal is not to catch your client in a mistake, okay? Your goal is to maintain a long-term relationship with your client. I can't emphasize this enough, okay? You're in business. The way to have the most efficient and profitable business is to have long-term clients that treat you well, that you treat well, and that keep coming back, okay? You're never going to build a great business on a bunch of one-off, one-off deals. It's these long-term relationships that will really benefit you and your business. And so you want to offer your contract at the outset, and you really want to offer your contract. Often your client will have a contract, but if you offer your contract first, it'll get the issue on the table. If they have one that they prefer to use, they'll send it to you right away. And suddenly you're talking about these complicated and scary issues that people often don't like to talk about, but now you're talking about them and you're moving on. So you want to have a standard contract, okay? That's the contract that when someone calls you and says, I have work I want you to do for me, you can say, oh great, well, let me send you my contract. And as soon as you sign it and return it to me, I'll put you on my book. So, you know, as I said, a basic contract would be oral, but at a minimum you want something in writing so that you have proof of your agreement. But really you want this personal contract that's designed for your business. You can turn to sample contracts and handouts as ways to look at areas you want to address or things you definitely want to make sure are in your agreement. But you really want to make sure that your contract is tailored to your needs. You don't want to grab a wedding photography contract off of you know, the PPA website, for example. I don't know that they have one, but you know, and then use it for your editorial clients because it's not tailored to those needs. You have specific needs for your business. Your clients have specific needs. You want to tailor your contract to those needs. So you've got a contract with a client. What happens when the deal is changed or broken? Well, the first thing you need to know is that once a deal is made, that's the deal, okay? Any change to the deal really requires additional, you can require something additional in exchange. So a good example would be if you've come to an agreement with somebody, after the fact they want more, you can ask them for more, okay? It's called a modification. Sometimes people ask me this question: can you cross out terms in a written contract that was sent to you by a client? Yes, of course. But of course you want to do it before you sign. You don't want to do it after you sign. But you're never going to be held to a term in a contract that you've crossed out before you signed it and returned it to the clients, okay? What if the client changes your terms? So you have done your due diligence, you've created your contract, you send it to your client, and then they send it back to you with something added to it. So this is an example of something that happened to me once. And of course this was a law firm client, but I had agreed to come take their picture, and it was a license for a term of years for them to use the work. So they signed it and they added at the bottom here, if you can see, it says photographer agrees that she will not publish, use, or allow anyone else to use the photographs that are subject to this agreement. So if you're in the photo world, you might recognize this as an exclusivity contract or a term. When somebody wants exclusive work or exclusive rights to use your work, that changes the value of what you're doing for them. And this is basically them asking for exclusive rights to use the pictures that I'm creating. So what do? Well, I wasn't comfortable with this, and so I rejected it. He sent me this, and I sent him back, and I said, I don't really accept this added term. You know, if you're uncomfortable with something, or maybe you can tell me why it is you want this added term, and maybe we can work something out that would satisfy your need. But generally speaking, I'm not willing to accept this. So, so that's what you do when somebody sends you something like this. If you're not willing to accept it, you tell them that you reject it, but you have to affirmatively reject it. If you don't, you're stuck with it, okay? If I hadn't told him, no, that's not going to work, then there would generally be a presumption that I'm stuck with that. Here we go, sorry. So I've had people talk to me about this happening to them, and actually it's happened to me as well. Luckily, I knew exactly what to do. But sometimes a photographer will get an assignment, they'll agree upon the usage, they'll agree upon the price, they'll deliver the work, they'll send the invoice, and you know, a couple weeks later they start questioning, and they get a nice call back that says, oh wait, let me send you our contract. We can't pay you until you sign our contract. So I want you to remember what we were talking about when a contract is formed. A contract is formed when the two sides come to an agreement. If that written contract just reflects essentially what you've already agreed upon, there's no problem with signing it. But let's say that you agreed to license the work for them to use one time, and the contract is a work for hire agreement. Well, they can't hold that over your head and say, I'm not going to pay you until you sign this work for hire agreement and transfer your copyright to me, or transfer your copyright to me. They are already obligated to pay you. So don't ever get stuck in a situation where you feel like you have to give more than you agreed to give when somebody tries to do something like that. Now, sometimes this is just an oversight, but you know, in my opinion, this happens because people don't want to have uncomfortable conversations about contract terms, and that applies to you know, middle managers who are in charge of hiring freelancers, who you know, just like photographers, often don't like to have these uncomfortable conversations, and so they just kind of put it off and put it off and put it off. But the bottom line for you is that if you've made an agreement with somebody and you've performed your side of the deal, they have to perform their side of the deal, and they can't extort something additional out of you. They already owe you. So the answer when they say that is, sorry, you know, you already owe me. So contract damages is something to be aware of. The benefit of a contract is that it binds both sides to the deal, okay? So you're obligated to perform your end, and they're obligated to perform their ends. But if they cancel the deal, you're entitled to damages. So this is probably money. The couple scenarios we've discussed involve, you know, somebody expecting money in exchange for their work. If the client doesn't give that money, they've breached the contract, and those are your damages. Now, the damages for your client, again, you're obligated to perform under this deal as well. The damages for your client can be a little more complicated, okay? Let's say you had to cancel at the last minute, your pictures disappear or get deleted, your hard drive, something goes wrong, your camera gets stolen on the way, car wreck, anything. Or, you know, worst case scenario, the client is unhappy with the work. In that case, damages for the client could include all kinds of things, like the cost of hiring a new photographer who might be more expensive. So if you have to cancel at the last minute and they have 3 hours to replace you, the person that they're calling to replace you knows they're in a bind and might, you know, give them a higher price. They're certainly not in a good negotiating position. In that case, you could potentially be liable for the additional cost, right? So whatever they had to pay to get that new photographer, you know, the difference between what they would have paid you and the new photographer, you could be liable for that. If you can't be replaced, but they've invested a lot of money in preparing for this shoot, you know, there could be some liability there. If your presence at an assignment would have brought in income, and they're no longer going to get that income because you broke your end of the deal, you could be liable to some of that. That may sound very scary to you, all this potential liability. I'm going to talk to you in a minute about something you can do to help limit this, okay? So that's a perfect transition into what should be in your contract, because this scary scenario back here is best managed by having your own contract that addresses problems. Again, we talked earlier about a great thing about a contract is it addresses what happens when something goes wrong. So some really important terms to have in your contract include a jurisdictional clause. I'm going to go into that. The copyright terms, what kind of license you're giving, who owns the copyright, that kind of thing. The payment terms, and what the client might be liable for if they do something wrong. Whether or not there's model releases, if this is a photo agreement, and limitation of liability, which is that last part I was talking to you about. For example, if the client rents a helicopter for this photo shoot and you can't show up for some reason, and they try to stick you with the helicopter rental, well, that's not cheap, right? So you want to limit your liability. When I was shooting, I would send out a contract that looks something like this. This isn't the whole page, but it gives you an idea. And what I did was I limited my my terms. I went through and figured out which terms and conditions were really important, because again, for me, a contract was about a relationship. And so what I did was I said, I want only the terms I absolutely need so that I can put them on the same page as my estimate or my confirmation. And that way, it's much more likely that my client is going to read it. I don't want to give my client a 10-page document that they're not going to read, because then they're going to make a mistake and they're not going to go according to our agreement, and it's going to ruin our relationship. So, so the idea with this for me was making sure that the client would read it and making sure that it was well understood. And I write things in as plain English as possible. But one thing I want to point out here is the location and time of the photo shoot, okay? Whatever instructions you've gotten from your client about the job you're about to do, you really want to include in your contract so that if you follow those instructions, you've performed. It's really clear and they've signed off on it. A jurisdictional clause, okay. This is something that I actually see missing from a lot of sample contracts. So you might want to make a note of this, and if you find a sample contract somewhere that you base yours off of, pay attention to whether there's a jurisdictional clause. Courts can only impose damages on someone if they're within their jurisdiction. So I live in San Antonio, Texas, which is in Bexar County, Texas. When I go to the Bexar County courthouse and ask them for relief against somebody, they can't do anything if that person has no connection to Bexar County, Texas. Okay, so if your client is in California and you're in San Antonio, Texas, you can't get a court in San Antonio, Texas to impose damages on a client in California unless that client has some sort of connection to San Antonio. The way you get around that is you get them to agree to jurisdiction. Okay, so this statement, client agrees to personal jurisdiction in Bexar County, Texas, is giving you a right to file suit where you live. This is really important because it makes the contract enforceable. Frankly, if you owe me $1,200 and I have to chase you to Chicago to collect, I'm probably not going to do it. But if I just have to walk down to the courthouse right here, I might do it. It's certainly much easier. Okay. Now, the need to sue a client is pretty rare. I've certainly never had to do it. So I've had situations where a client says, we don't want to agree to personal jurisdiction in San Antonio, so, can you agree to personal jurisdiction in Chicago or New York or whatever? I usually just say, sure. I don't mind negotiating on this point, but as a standard point, it's good to have your personal jurisdiction where you live so you can sue easily if need be. Let's hope you never have to, though. You also want to have your copyright terms in your contract. We all know, because we listened to the beginning of this webinar, that the default is that you keep the copyright. but your client might not know, okay? I can't even tell you how many editors who just don't know that very basic point about the law. And so, again, my goal is not to get my client caught in a trap or a mistake. My goal is not to be hauling my clients into court. My goal is to help them so that we can have a good long-term relationship. So I tell them, right, in several different ways. The rights granted are right here under rights and uses granted. Talk about the edited selection of images I'm going to provide. Clarify that you're an independent contractor, not an employee. I mean, you can say it in a million different ways. It doesn't hurt to say it in a few different ways, that this is not a work for hire. And, what happens if they get a request for reprints? Well, this is what they're supposed to do. The rights can't be transferred, all this stuff. This is, helpful stuff to write. And it's just good because your client's going to read it and it's going to put them on notice. And then if they want greater usage, they'll bring it up, they'll talk to you. You can say, well, if you want more usage, it's going to cost you more, okay? You want to put payment terms in your contract. There's a couple reasons. One is because it gets that issue on the table again. Maybe their accounting department is slow and they're not going to be able to pay you for 60 days. Well, you want to know that up front because maybe you're going to charge more if you're going to have to basically float them a loan for 60 days. A lot of people require payment before the work begins. That's certainly okay. I like to put in there that no rights are granted until the payment is received in full, and that not paying is a copyright infringement, not just a breach of contract. And it's also helpful to put in there a clause that says if you have to get an attorney to help you enforce this agreement, they have to pay your attorney's fees. The default in U.S. courts is essentially that when there's a lawsuit, each party pays their own attorney's fees. That makes it very difficult if you're fighting against a big company to to put up a good fight. But having a term like this in your agreement will help you. You want to address liability issues. So along those lines, you might want to offer a warranty to your client, right? You warrant that you took the pictures or your subcontractors did. I like to put subcontractors in there because if I do have something go wrong, let's say I get sick, I like to think that I could call somebody who I know is of equal skill and get them to take my place and subcontract the work, and you've still met your agreements. Then you don't have to breach your contract in order to help your client get get what they need. So just want to make sure that you're asserting that you have the authority to license the use. But the important thing here is that the client needs to accept liability associated with the use or misuse of the images. So let's assume you're hired to take a picture of a mother and a child for a story about working parents, okay? So maybe it's a sweet little picture of these two people. Well, let's say your client in 6 months is doing a story about child abuse. They look through their files, they see this picture, they go, oh, well, here's a picture of a mother and a child, and we're talking about child abuse, let's use it. Let's hope that never happens to you. But if it does, you want to make it clear the client's liable for that stuff. Okay, you want them to indemnify you against anything they do wrong with your work. And it doesn't have to be that egregious, right? It could be something as simple as a misplaced headline, or let's say you write an article about something and a copy editor comes along and corrects a fact in the wrong direction so that it's actually no longer a fact, it's now a defamatory false statement. So this is negligence, but you don't want to be liable for it. You want them to be liable for their mistakes. Sometimes there's a mutual indemnification, so you could say, if they want, you could say, well, I'm liable for my mistakes and you're liable for your mistakes. That's also useful. Now that we're talking about things like being liable for big mistakes like that, I just want to throw in a plug here that If you're in business, it's a good idea to get insurance, okay? You can get business insurance, errors and omissions insurance, that kind of thing. You want to make sure that if something goes wrong, sometimes things just happen, you know, and you don't want to be left in ruin just because something like this goes wrong. If you're a photographer, it's good to talk about model releases. I like to say that, you know, if it's not in your hand, it doesn't exist. That way they can't say that they've relied on their assumption that you got a model release and you stuck it in a drawer somewhere. If I get a model release, I'm going to give it to you and you stick it in a drawer. You know, but I will provide it for you, and if it's not provided, you must assume that it doesn't exist. Now, earlier when we were talking about what could happen if you breach the agreement or the client doesn't like your work, this is where the second part here comes into play. You want to say your liability should be limited to the refund of the total fee paid. Okay, so essentially, let's say the client pays you in advance, and then they say, well, I don't like your work. Well, okay, my liability in this situation is that you get your money back, okay? My liability is not that you get to restage the event that you know, was associated with this work. My liability is limited here. So now we've talked about what might be in your contract. Let's talk for a second about what you might find in your client's contract. Now, this was pulled from a photo contract several years ago. It's probably different now, but these are terms that you might see that I've certainly seen before. Okay, work for hire, copyright transfer. This is typically what it looks like. You see these words, work made for hire. Any work submitted shall be considered a work made for hire. Not everything is eligible for work for hire status under the copyright law. So that's why you'll often see this second clause that says, if for some reason it's found not to be a work for hire, you know, you acknowledge that this agreement transfers the ownership of the copyright. So remember I said there were two ways to get a company your copyright. Typically you'll find both of those methods in a contract if that's what they're trying to accomplish. And remember, just because you see this in your client's contract doesn't mean you have to agree to it. And it doesn't mean you have to accept the assignment. Maybe this isn't the assignment for you if you don't like it. You're going to see, probably going to see an indemnification. Some are better than others, okay? You see here they're warranting that you're the sole creator. There's nothing wrong with that. They're talking about this warranty here, this guarantee, is that the reproduction, publication, or distribution will not infringe upon or misappropriate the rights of any third party. That sounds innocuous enough, but remember, you just transferred your copyright to them. What does that mean? They can do anything they want with the work, okay? This second part doesn't defame anyone or invade their privacy, not second part, but under Part E. So let's assume you license a photo to them, or you take a photo for them and you think it's for using in a news article. But because they own the copyright, they can do whatever they want with it. So maybe they start using it because it's a great picture. They start using it to advertise a product. And, well, if there's people in it, those people are in advertising, they might sue you for misappropriation of likeness, which is actually a privacy tort, okay? So an invasion of privacy covers more than just, you know, I was creeping around your window and being creepy. Invasion of privacy covers misappropriation of likeness, or the kind of tort that comes when you don't get permission from using somebody's picture in an advertisement, okay? So there you go, you're in trouble because you've given them the copyright, they can do whatever they want with it, and you've guaranteed that it won't violate anyone's rights. And now on top of that, here you are, you've indemnified them, which means that anytime there's a liability that arises out of their use and your failure to get a model release, you're on the hook. That's what it means. So again, if you find yourself signing this kind of agreement, you want to make sure that you have good insurance and you talk to your insurance agency about these kind of agreements, and just check with them and say, you know, hey, if something goes wrong, am I covered under my policy? And if not, what can we add to my policy that will help me here? Something else that might be here is responsibility for permission to use the work or the subjects of the work. If consent is required, you know, they might say you're responsible for getting it. So I think that, you know, as I discussed, contracts are negotiations about building successful relationships. You don't have to have agreements and relationships with everybody that shows up at your door. So I'd like to talk about the power of saying no and the power of really sitting down with yourself and developing policies. I really like to say things like, my policy is, or I have a policy that requires this. You know, think about it like this. You're a business, okay? Whether you're an informal business or a formal corporation, you're a business. And so you need to have policies. How are you going to run this business? What are you going to do? What are you going to agree to? What are you going to not agree to? And enforce them. I had a policy when I was a freelancer. I never transferred my copyright. Some of that was because I wanted to be able to reuse my work. Some of it was because I was lazy and I thought, I don't want to have to think about whether I can you know, reuse this work down the line. I just want to know that I own all my work. Oftentimes you'll get lowball offers. So, you know, be willing to say, okay, well, let me know if your budget ever changes. Believe it or not, budgets change. People will come back to you for better work down the line. Maybe that person will end up at a different company who has a better budget. Or maybe they'll have a project down the line that's more in line with what you do. The only way you're going to be working with clients that you like and that are your goal clients is if you're not wasting your days with clients you don't like. And be comfortable with the word no thank you, okay? It's okay if it doesn't work out. A lot of people will put out 3 bids. Those folks are often looking for the cheapest person, but you know, if you don't close the deal every single time, it's not a huge tragedy, okay? It's just part of business. Remember that this is a business negotiation. If it doesn't work out, it's okay. Just, you know, maybe the next one will work out. And if a potential client goes somewhere, it's not always a reflection of you, okay? It's not a personal rejection. It's just a reflection of what they need. And that doesn't necessarily match with what you're willing to do. And finally, I just want to drive home this point. Contracts preserve relationships. Make sure that you have good written agreements with your clients, and that will help them be long-term clients that you can turn to again and again. So, Shannon, I want to thank everyone for listening, and I think we have maybe a couple minutes if there's any questions.
Yeah, we got 2 questions for you. So first one is from Fabiola. She's asking, in the slide where it says work for hire, and you were talking about how you need a written contract, she was asking whether the contract needs to be signed by both parties or just the photographer in that case.
The person who's transferring the copyright.
Okay, so in that case it would most likely be the photographer.
Yeah.
Okay, and then our second question came from Mariko, and she was asking, she was saying how, you know, you're mentioning words like exclusive rights and broad usage and also embargo. She was asking what other terms freelancers might want to familiarize themselves with, as well as any resources you'd suggest for familiarizing yourself with more legal terms like that.
That's a good question. I think just reading. ASMP has a lot of good business resources. National Press Photographers has some too. Professional Photographers of America, I think, has some as well, as does APA, American Photographic Artists. So I would turn to trade organizations for that kind of information. And I would look at sample contracts. There are definitely a lot of them on the internet that you can poke around at and that would have terms like that. And you bring up a good point, okay, which is that a lot of people are very scared of contracts, and one thing I encourage people to do is just read them over and over and over again. Find contracts that are in your industry, and you know, every time you come across a term and you don't know what it means, figure it out. And that's the best way to familiarize yourself with contracts. Just like everything that you do, the more you're familiar with it, the easier it'll come to you. And before you know it, you'll just be rattling off these terms like you've spoken them all your life. But it takes familiarity and it takes time. And so that's a great idea to find those terms and familiarize yourself with them. I would say there's probably an endless supply of potential terms. I don't particularly have a list myself, but I would just try to turn to contracts and ask other people in the industry for copies of contracts that they've signed as well, and that would help you.
And also, would you just really briefly go over, I know a lot of us use social media to help get our work out there, and I feel like there's some confusion sometimes as to like who owns that copyright once you put it out there, especially because sometimes if you're like tweeting a photo or something of that like, and then it starts get retweeting by different, you know, news sites and stuff, who owns the copyright at that point?
So this is one of those answers that I'll give that is, it depends. But typically, well, always when you upload something to social media, you've agreed to the terms and conditions of that venue or that social media sphere. So sometimes those terms include broad reuse rights to the social media company, and sometimes that extends beyond them. You still retain your copyright, but you have granted them the right to do just about everything with it. Some of those rights that they ask for are necessary as part of just carrying out the function of social media. So for example, if you put something on Twitter and you know, it goes through the Twitter sphere, and you know, it needs the right, Twitter needs the right to do that. So they ask for these broad rights from you. That doesn't necessarily mean that a third party can take what you put on Twitter and use it for their own purposes. But it does depend on what those terms and conditions are. So every website, every social media site, Facebook, Twitter, YouTube, all of the above, they all have terms and conditions. And it's really, if you're going to put valuable content on social media, it's a very good idea to read those terms and conditions so that you know what can happen with your work.
All right, we got time for one more question, and it's from Meredith, and she's asking, it's about questions. So she's asking if you know, if we have specific questions regarding contracts, is there a resource, like do we have to go directly to a lawyer, or are there free or cheaper resources for reporters and photographers who are just starting out and trying to find out more?
That's a great question. Typically, you can turn to some of the resources I raised earlier to see if you can find your answers there. I would shoot for that before I you know, invest in a lawyer to answer a specific simple question. But a lot of times questions just aren't that simple, and a lot of times people will call me with one question, and I'll notice something in their fact pattern that actually there's something else going on there that they need to know about as well. You know, that's the advantage of an attorney, is they'll spot these issues that you may be facing based on what you present them with. So yes, I encourage you to call a lawyer. Generally for NPPA members, if they have general legal questions, Mickey Osterreicher and myself will be happy to answer them. So that's something we do for NPPA members, but they're general legal questions. If you call me and say, I have a contract from a client and I want to revise it, can you help me revise it? Well, that's really legal representation, and that's not something that you're going to get a lawyer to do for free, even a lawyer who's generous with their time.
Okay, great. I thank you so much, Alicia, for your time and for doing this. We appreciate it immensely. Everybody, thank you for tuning in, and hopefully you'll come back for one of our future talks. And I hope everyone has a great day, okay? Thank you, Alicia.
It's been a pleasure. Thanks, everybody. Take care.
Bye.